common question we get is, what's the process of getting divorced? Well, unfortunately, it's not a straight line, and I'm going to outline 12 steps for you, but they're not linear. You might be able to skip some of them. Some of them may not apply to you. And most importantly, we have 100 counties here in North Carolina. Our law firm, Triangle Smart Divorce, is in Cary, North Carolina. So, what I'm talking about is applicable to Wake County, may not be applicable to you, could vary for you, and you need to consult with somebody in your area to find out. But this is a great general overview. So the first step is schedule a consult with a lawyer to talk about getting divorced. Don't start the process without a plan, without a strategy. Find a qualified lawyer in your area who does divorce. It doesn't have to be a certified family law specialist, but that could help. Also, it doesn't have to be somebody with 20 years of experience, but that might be a better fit for you if you have a complicated case. And in your county, if you're in a small area, maybe you have to see someone who does traffic law and estate law and family law. But if you're in a larger county, like we are here in Cary, then I recommend you go to someone who specializes and only does divorce. So, what should you expect of this consult? You should expect to be asked a lot of questions, and this is so we can gain a clearer picture of what's going on to give you custom advice tailored to your situation and what's important to you, not just generic, well, this is when you can file and these are the claims you can make, but actual things that talk about your goals and help you spot obstacles that you might encounter along the way so we can help you create a plan. What makes for a great divorce consultation? Well, it's one that you leave with specific action steps so that you know what to do next and what to expect next. And most of all, remember, just because you saw a divorce lawyer doesn't mean you're getting divorced. It just means that you care enough about your future that you want to know answers to questions in advance. You don't want to leave things to risk, and you want a solid strategy and plan about what your next steps are. We also get asked a lot, well, how do I find the right attorney for me? Well, that's not always an easy thing, and sometimes you may need 2 or 3 consults with different lawyers or different law firms to find the right fit. Ultimately, you want someone who respects you, values your time, values your money, and someone you feel like is going to be a good advocate for you. And that's why it might take 2 or 3 consults to find that right fit. However, when you find that right fit, you're going to know you're with the right person because you feel like you're being protected and you feel like somebody's looking out for you. Yes, every once in a while, we're going to challenge you, particularly if you're asking for things that we know there's no way in heck we could get for you in court. But we're going to explain why we're challenging you. We're not just going to disagree with you to disagree. And to help you with this process, we've created a guide about 10 things you should ask any divorce lawyer before hiring them, including us. And one of those questions that I think is really important is, do they have a team? Are you going to be able to talk to somebody if your lawyer's sick or in court or on vacation? Are you going to be left alone for days or weeks not knowing what's going on in your case? If you hire a team, that can actually save you some money and give you some peace of mind. Now, the step that we put here in the third place is about gathering documents. We put it here because most people wait to do this until after they hire an attorney. But frankly, maybe you should do it before you hire an attorney. The important thing to know is you're going to have to do it if you're going through a divorce. If you have any assets whatsoever, or if you earn any income, you're going to have to do it. And the reason why is because we need to know, and your spouse needs to know, what are the assets? What are the debts? What are the monthly obligations? What expenses do you have? In order to be able to put together either a settlement proposal, a full-on separation agreement and property settlement, or to prepare you for court. So accept the fact that we're going to be asking for a lot of documents. And when I say a lot, I mean back to the date that you separated, and maybe even before that, because North Carolina bases asset division on date of separation. So we have to know what you had then. If you haven't separated yet, then really we're just looking for the last couple of months. We have a lot of pushback from people sometimes saying, well, you don't need that. We're in agreement. We don't need this. We think this is a fair resolution. And maybe it is. But as your lawyer, we can't help advocate for you and make sure you're making smart decisions unless we review the documents and give you our opinion and our advice about what a reasonable settlement might be. So, like I said, we're going to ask for a lot of them. Try to do them all up front because the more you get to us the first time around, the less we have to follow up with you and the less money that you'll be charged by the law firm for chasing down your documents or having to go somewhere else. And another important thing about documents is we're going to be asking for the same thing from the other side. But if you have some of those documents already, you have access to their bank accounts, you can give those to us, and that will save you some time and money as well. And most importantly, maybe you decide you don't want to go through a divorce and you're like, I don't want to waste my time organizing this stuff if I'm not going to go this direction. Well, maybe that's the right decision for you. But we find for a lot of people, they appreciate our guide on what documents we need and how to assemble them and how to put them together, even if they end up not going through divorce, because it helps them get organized in their life. Helps them get organized for next year when they have to file their taxes. Helps them get organized for their estate plan. Or if something unfortunate happened to you, helps your family be able to find where your assets are, where the life insurance is, where the disability policy is, so that they can help the rest of the family with support in the event something unfortunate happens. So you're going to hear it again a lot through this 12-step process. There are lots of documents we need. I hate to say it, but get used to it. It's part of the process. The fourth step is answering that question that the clash posed. Should I stay or should I go? And why do we have that fourth instead of first? Well, because it is a personal decision you need to make, but a lot of people don't want to make that decision until they know what their financial options are and what the legal process might look like, because they want to make a smart choice. They want to make an educated choice. They want to have all the information available to them and not just make an emotional decision. I'm not saying making an emotional decision is bad. I'm just saying this is why we put this forth, because we find most of our clients want to know what life might look like if they separated or divorced before they make that decision. We also put it forth because we can help you with this decision. Not actually making the decision, that's a personal one, but we can help you about delivering the decision. If you decide it is time to go, we can help you find a couples therapist or individual therapist. If you say, you know what, I'm not ready yet, I want to try to make this work. I want to see what happens if we really dedicate ourselves to working on the marriage. And lastly, we can create for you a post-marital agreement. This is what couples do sometimes when they decide that they're going to stay together, but they want to put a plan in place for how assets and debts are divided in the event they separate. So again, we're here to help you and guide you every step of the way, no matter what your decision is. The fifth step in this divorce process is getting a settlement proposal put together. So what does that mean? That means that we look through all these documents that we asked you to get and all the documents we asked for from the other side if we have informed them that you're thinking about separating, and we put together on paper what you want. This is a great way to start the process because it puts out there what you need, what you want, and what your goals and what your hopes are with a resolution. Now, it's possible that that might not be agreed to, and there might be a little bit of back and forth here, and we'll talk about that more in the next step. But this is where a lot of people exit the process. They get off the road here of divorce and separation because they're able to reach a resolution that saves them time, money, energy, and stress. And I think it's important to note here, we can do all of this before you ever separate. In North Carolina, as you may know, you have to wait a year and a day to actually get the piece of paper that says you're divorced. Well, actually, it's longer than that. You have to wait a year and a day to file to be able to get the piece of paper to say you're divorced. But you can work out everything else before you even separate. Or if you can't do that, you can work it out after you separate before your divorce is final. We're not like other states where you have to wait. So this is an important step here where we can really focus on getting you what you want and keeping you out of court, where a judge would decide what happens to your future as opposed to you. So all those documents I talked about before, they're really important here because we're going to sit down and go through them and try to figure out what a reasonable and equitable settlement is and get your input every step of the way about what you want. Step 6. This comes up if your initial proposal was not accepted for how to resolve property division and support and other issues. This is where the decision is made about whether or not you negotiate, whether you mediate, or whether you file, or you do all of those things in that order, roughly. So what does that mean specifically? It means you could trade settlement proposals back and forth with your spouse, through your lawyer, of course. And then you could decide, do I want to make a compromise there because that thing is not as important to me as this other thing over here that I really, really want? That's what negotiation is. Mediation is just another form of negotiation. The difference is you have a neutral person who goes back and forth between you and your spouse and your lawyers and helps you try to reach a resolution. So you have a little bit more guidance in the process than just working through your lawyers. And sometimes a mediator can help you get unstuck. We're going to talk later about mediation if you have a lawsuit. So I'm going to save that for later. For now, what you should know is if you're not successful in resolving your issues with proposals and exchanging them, you're not successful in mediation, then you might make the decision that court is the right place to go next. I say might because court isn't for everyone. Maybe it's to your advantage not to have things resolved yet if they're not on your terms. Maybe it's not. And these are things that you need to talk to an experienced lawyer about. But what does it look like if you file? That basically means that you are now asking the court to take control of your case and make decisions for you in the future. It doesn't mean you still can't negotiate and settle and go to mediation, but it means you're turning it over to the court in the event you can't. It's sort of like the last resort, if you will. So that a resolution will come up. It just won't be one you agreed to. And one more thing that's important here about filing for property distribution, filing your issues in court, is a lot of clients say to us, but I can't afford it. You told me how expensive litigation is going to be. Well, first of all, I would say expensive compared to what? Compared to living in the life you've been living in, compared to not having access to your money, compared to not getting your share of all the things you've accumulated during your marriage. So let's think about that word expensive and what we mean when we say it. But also know that if you have assets, we can file what we call an interim allocation motion. It's just a temporary motion that says, hey, judge, we need to free up some money because my client needs to be able to hire us. My client needs to be able to pay a retainer to an expert, maybe if there's a business involved, or my client needs some money to live on until the time that we can get this worked out. So don't lose hope if you think you can't afford to file a lawsuit if you're stuck in that position where that's the next step forward, because we have ways of helping you with that too. Step 7 for after you file the lawsuit is mandatory initial disclosures here in Wake County. Other counties may have different rules, but in Wake County, if you have claims for property division, if you have claims for any type of support, you're going to have to produce financial documents, more than we asked you for when we were drafting your settlement proposal. And this is mandatory. I know I said that at the beginning, but I want to stress it. There are serious repercussions if you don't do it. You could be prohibited from putting on evidence at your hearing. You could have to pay the other person's attorney's fees. You could also have your claim completely dismissed. There are big time repercussions to this. So when your lawyer says, we've got to do this, they mean it. They're not just asking for a bunch of paper for the heck of it or to run up fees. It is required, it is necessary. But remember, if you put this stuff together for us in the beginning, like we asked, really all you got to do is update it for the areas where they ask for more detailed and longer periods of time in initial disclosures than we may have asked you for to draft a separation agreement. So this is an important step. It's very significant. Can't skip it. So help your lawyer help you and gather everything you can as quickly as you can. Maybe even before you file a lawsuit, because these time frames are really short. Step 8 is having a temporary hearing or two, if applicable. And what I mean by if applicable is you may not need one if you have stability in your separation. You may not need one if you don't have a financial imbalance. But if you have either one of those things, for instance, you can't agree about custody and you're racing to the daycare, you're racing to the school to pick up your kid, and he or she with the child makes the rules, then maybe you need a temporary custody hearing. If you can't pay your bills because you were relying upon the other spouse, maybe you need a temporary support hearing to get some money flowing. If the other side's not paying child support and they should be, maybe you need a temporary child support hearing. So I say if applicable. If these things don't apply to you, this is a step you can skip. But I think what's important to know here is it can take a long time to get to court to resolve all the issues finally. So these temporary hearings are put in places that have family court so that there are little mini 1 hour, 2 hour hearings on very limited evidence to help you get an order to put a band-aid on a situation so that you're not left struggling all alone until you get a final court date. So the next step in the process after you file, and even sometimes before you have a temporary hearing, is court-ordered mediation. Now in Wake County, that only relates to child custody and equitable distribution or property division. Doesn't mean you can't mediate other issues. That's just the only 2 areas which mediation is ordered in. They're different though, so I'm going to break them down. Court-ordered mediation for custody is free. It is part of your tax dollars at work. You have a mediator who's an employee of the county system, and they help you try to work things out without your lawyers. But that doesn't mean your lawyer can't be involved. We can meet with you in advance and help you plan and help you create a strategy and help you think through where you might be willing to compromise and what are non negotiables. So involve your lawyer. Don't just go to custody and think I can work this out myself. That usually happens virtually these days, post COVID era, over Zoom. Used to be at the courthouse, now it's mostly virtual. The other type of mediation is family financial mediation, which really just means equitable distribution and any other claims you voluntarily agree for this mediator to do. What's important to distinguish here from this from custody mediation is it's not free. You have to pay the mediator and you pay your lawyer to be there with you. But unlike custody mediation, you can walk out of this with a final resolution, be that a consent order or a separation agreement resolving your case. In custody mediation, you get a draft parenting agreement emailed to you, which the other side may later refuse to sign, or their lawyer or your lawyer might tell you there's some terms in there that don't make any sense and you should go back to the table and negotiate again. Contrast that to family financial mediation, where your lawyer's with you, a document can be done, a document can be signed, and you can exit out of this process there and just wait your time to get divorced. So, this is two big distinctions on these things. I think the other thing to note about court order mediation is sometimes people say, well, we already went to mediation before we ever filed the lawsuit, or right after we did. Why do we have to go back again? Well, sometimes it takes a while for both sides of the equation to get up to the point where they're ready to resolve things. Maybe that's a timing issue. Maybe you've known for years you wanted to separate and this was news to your spouse and they're still emotionally catching up. Maybe you had to go to court at least once on a temporary hearing and the judge ruled against your spouse for them finally to be willing to negotiate. So don't throw it out the window and think, this is dumb. I've already done this before. It could be very valuable. And we've seen it happen a lot where people did not successfully resolve their case before filing and then went to mediation after a lawsuit was filed and walked away with a full and complete resolution. So don't lose hope here and don't think just because you filed a lawsuit, you're going to have to go to see a judge. Step 10 is one that may also not apply to every single person going through divorce. It's called the discovery process. You may have heard these words on TV like subpoena or interrogatories or deposition or request for documents. And one you probably haven't heard is request for admissions. And what are all these things? These are formal document requests, formal questions, document requests that go to third parties like a bank in order to get more information. And you're probably thinking the same thing that I feel, which is, why do we have to do all this when Wake County has initial disclosures? I thought I already gave you every document you needed. I gave you every one the court said I had to do. Well, here's one thing. Initial disclosures only apply to financial things, like property, like support, like finances, like debt. There aren't any disclosures at all about custody-related matters. The closest thing there is child-related expenses, but nothing about custody itself. So you may have a custody case, and it may be that your lawyer says, you know what, we don't want any surprises in court. Let's ask them in advance why they said you shouldn't have 50-50 custody. Let's ask them in advance why they said you should have supervised visitation. Let's find out their reasons why, and let's see if they have any documents to support those things. That would be a reason to use discovery. Another reason would be, frankly, the approach of initial disclosures in Wake County is kind of limited. It's limited to cases where people own property, like a house or retirement or cars or banking accounts or investment accounts, but they're not really aimed very well at self-employed people or business owners. So if you have a case that has something like that in it, you might find that you need to ask discovery questions or subpoena documents from someone in order to get more information so that your lawyer can help you know, with help of an expert, what the value of the business is or how much money a self-employed person really makes versus what they might tell the IRS. That would be another reason for discovery. And a really good third one I can think of is you have a spouse who just won't do the initial disclosures. They're mandatory and there's repercussions for them and they can be punished for that. But at the end of the day, you need the documents in order to present your case in court. What if they're sitting on a pile of retirement? You don't have access to those documents and they won't give them to you. Sure, the judge can say, well, they can't put on any evidence about what it's worth, but that doesn't help you any because you need to know what it's worth, so you need to know what your share of it might be. So you may need to subpoena the retirement institution to get statements. These are all things, again, that we don't use every day in our lawsuits, but sometimes we do. So I want to put it out there and let you know about them. But I also want to let you know that there are repercussions here again if people don't produce what they're supposed to produce or don't answer what they've been asked to answer. Unless there's a reason to object and the judge thinks that's a reasonable objection, they've got to answer these things too. And there are punishments and fines and penalties if they don't, just like with the mandatory disclosures. So discovery can be a really useful tool in your case to help you know what the whole picture looks like and to help you determine your strategy for litigation when you have a hearing. 11 isn't really a step in and of itself, but it's an explanation of what pretrial conferences are. Depending on your county, you may have pretrial conferences. In Wake County, again, mandatory because we have family court, that you have 3 pretrial conferences. I call them pretrial conferences. They have slightly different names, but 3 pretrial conferences in any case which there's a property division claim, an equitable distribution claim. And the reason for these is so that your case moves along. We have these things in Wake County called time standards. And your equitable distribution case is supposed to be done about a year from when the case was filed. Now, I'll tell you, my experience has been, again, post-COVID era, and even before, that doesn't happen so much for various reasons. A lot of it being our courts are understaffed and we have a huge backlog of cases. But nonetheless, that is the reason that these are in place. Not only to help you narrow issues, but to help move the case along. So the first one is a scheduling and discovery conference, and that's nothing more than picking a mediator if you can, if not, having the judge appoint it for you. The mediator we talked about before for the court-ordered equitable distribution family financial mediation. It's helping the court know whether or not they're going to have to appoint an expert in the case or whether you can agree to one or whether you're going to hire your own separate ones. It's setting deadlines for when the next pretrial conferences are and for when equitable distribution inventory affidavits are due. That's a big phrase. That's part of initial disclosures, but that's all part of this process. The next one is an initial pretrial conference, which again is just a deadline thing. Checking in on deadlines, seeing were these deadlines met? If not, what are the new deadlines? And what deadlines are we setting for the ultimate hearing in the case? Are we still on schedule or do we need to push those out? The big one is the final pretrial conference. This is the one where the court wants to know, is there anything these folks can agree to? Is there anything they can stipulate to? What are the contentions of each person? If somebody says, I'm entitled to an unequal distribution of property, court wants in the final pretrial conference the reasons why. Not the details behind them and not the evidence, but the reasons why. So the court knows, hey, I'm going to have to hear extra evidence in this case to determine if 50-50 is not fair. Also, the court wants to know, do they agree? Is this asset marital? Is it not marital? Is this asset worth this or is it worth that? So it's a focus on narrowing the issues so that when you're ready to actually have, and the court is able to hear your equitable distribution case, if you have to end up there, then the court knows what the issues are it's considering before the evidence is even put on, so that the court can streamline the process and only truly hear the issues that have contentions that are different, so that you don't waste time going through everything you already agree upon. So the whole point of these things are to streamline and to keep you on a schedule. That's what pretrial conferences are for. The 12th and final step, no matter where you entered this process, is resolution with trial in court. Now, I think it's important to note that different claims in your case can be tried at different times. It would be very unusual for your custody hearing to be at the same time as your property hearing. So what I'm talking about, know that this applies to every single claim in your case, whether that's custody, whether it's property division, whether that's alimony. You might have 3 separate permanent hearings. Don't know, because it all depends upon the court calendar and when we can find available time. That is a whole nother video I could shoot about the debacle known as the Wake County court calendar and getting things heard. But anyway, what you need to know here is it takes a long time to get a final hearing. It can take months, often years, to actually get heard. You may not get heard the first time that you schedule your hearing. You may get bumped. The judge could be sick. The other lawyer could be sick. You could be sick. There could be 10 cases in front of you that day, and the judge has no way to get to you. And then you have to reset your hearing. It doesn't get reset for the next day or the next week. It gets set months down the road. So this is a slow process. And if anybody can tell you how quickly you're going to be heard in court and whether or not you have a 100% chance of getting reached, I would suggest you walk away from that person because they're just telling you lies. There's no way to know. We do our best, but there's no way to know with certainty how quickly your case is going to get heard in court and whether or not you're going to get reached when we set it for hearing. That's not how it works in Wake County. Another thing to know here is even though you have your trial, you may not get your decision that day. In fact, it's very unlikely you'll get your decision that day. We've had cases where we've gone months, sometimes more than 6 months, without getting the decision from the judge. And we know that's frustrating, but there's not much we can do there because the judge has to do it on their timeline. All we can do is set a motion for entry of order at an appropriate time. And our judges have had many meetings with lawyers, not in our firm, all the lawyers in the county, to say, don't do that. Give us at least 3 or 4 months before you ever do that. And before you do that, contact our case coordinator so you can see where you are in the status of our queue. Because, hey, they're in court every day. They don't have very many administrative days. And when they do, they often get pulled into another courtroom to cover for someone else. So it is a great exercise in patience when you have to have your case resolved in court. It is very frustrating, and we know it. All we ask is that you know that at some point a decision is coming and the end is near. Another thing about court that I want you to know is, in our experience, it takes about 3 times the amount of time we have allocated for your hearing to actually prepare thoroughly and get ready for your hearing. Going through all these documents you gave us, going through all the documents the other side gave us, looking at the text messages that have been exchanged, particularly if it's a custody case or a business case or one with a self-employed individual, it's going to be a process, and we want to be thoroughly prepared to get you the best outcome. So a trial retainer deposit will be requested. We can break those up and we can work with you on that for a schedule. But know that court does cost significantly more money than resolving things outside of court. And this is part of the reason why, because of the preparation. But it's also part of what I talked about before. We maybe get ready, and then your case doesn't get heard. And then we have to get ready again and update it again with new information, because your life doesn't stop when your case doesn't get heard. Things are constantly changing. Maybe the custody has changed a little bit. Maybe you have a new concern you didn't have before. Maybe somebody's gotten a new job. Things can change, and regardless, values and accounts do change. So we have to update everything and we have to prepare again. Not from scratch, but we have to supplement and we have to prepare again. So that can cause your case to cost you more money as well. So for all those reasons, that's why we've been working in a lot of these other 11 steps to get you exited out of this process without actually having to go to a final hearing or a trial in front of a judge. Because we know how costly court can be, and we know how frustrating it is. And we also have seen it when the judge takes control of the case and makes decisions that you don't like, that have taken you completely out of control of your future. And we don't think that's usually the best for you. We will do it if your case calls for it. Sometimes your spouse cannot be reasoned with. Sometimes your spouse will not agree to anything. In those cases, we roll up our sleeves with the best of them and go into court and give you the best defense or the best prosecution that you can have of your claims or defense of their claims. But at the end of the day, when we put it in the court's hands, it's all up to what that court thinks is right, what that court thinks is best, and frankly, who that court sides with more than the other in any areas where there's a dispute of fact. So this is why we always advise you with what might happen in court, but then tell you these are your options without going to court. Because sometimes it's better to have a resolution and not get everything that you want than it is to risk it all by going to court. And I know this was a long video, but I wanted you to get clarity around all the steps, all the processes involved, from starting with contacting a lawyer all the way to if I have to resolve everything in the courtroom. And again, like I said in the beginning, this isn't linear. You don't have to go through every one of these steps. Some of them may not be applicable to you. Some of them you may double back and do a step again, like mediation. Some of them you may not do, and then later you decide you need to do, like discovery. So don't think of this as a step 1, step 2, step 3 process. Think of it more like a nice country drive where you're like, where does this road go? And that road led to that, and that road led to that, but I don't want to be over there, so I need to go backwards and take another road because these roads don't interconnect sometimes. It can be confusing, and that's why you want to have an experienced divorce lawyer on your side to help guide you through this process, to frankly be your chauffeur on this road. So call us if that interests you and you don't want to go through this alone and you want to know someone who knows every avenue to get you to resolution.